I'm Abby Marr, and today my colleague Adam and I will walk you through this module entitled Title IX Final Rule Basics. This module will explain federal compliance requirements for how colleges and universities must respond to reports of sexual harassment and sexual violence under Title IX. We'll be covering these requirements step by step, looking at every stage of the process, from the intake of reports to the filing of formal complaints, to the investigation, hearing, and appeal processes. We won't cover any topic in tremendous detail. The goal here today is to guide you through the major issues, and at times changes from previous guidance and judicial precedent. The first goal of this module is to provide a high-level overview of what federal law and regulations demand when a college or university receives a report of sexual harassment or sexual violence. Even if your role in the Title IX process is limited, it is vital to understand the bigger picture. By learning the scope of the law and regulations, we hope this module will aid you in developing policies and practices that follow the mandates, particularly where the new rules, issued in final form on May 19, 2020, may not conform with your code. And we also intend that this introductory module serve as a guide to further instruction in our bank of learning resources on Title IX. So a bit of a roadmap for our time together today. We'll review a brief history of the Title IX final rules, including prior guidance on sexual harassment and violence response. Then, we will discuss the scope of the Title IX grievance process under the final rules, including a brief overview of the meaning of sexual harassment, how an institution learns of sexual harassment, and what people and locations are covered under an institution's Title IX jurisdiction. Next, we'll look at the intake process, including the provision of supportive measures and emergency removals, the filing of a formal complaint, and, when necessary, the dismissal process. Then, we will look at the investigation itself, including the notice of allegations, the inspection and review of evidence, and the drafting of the investigative report. We'll examine the role of advisors in the process, including how the advisor requirement has changed from the Violence Against Women Act amendments to the Clery Act to now. After that, we will review the mandate for a live hearing with cross-examination. Then we will look into the new requirement for an appeal and what grounds can be raised for an appeal. As it comes up, we'll also examine rules regarding conflicts of interest, bias, and retaliation. Again, this module is only an introduction to the process, and members are advised to watch our companion modules to learn more. So a bit of the history. The U.S. Department of Education's Office for Civil Rights, or OCR, issued its first guidance document on sexual harassment in 1997 in response to a growing number of complaints filed with the agency. Shortly after issuance of the guidance, the Supreme Court issued decisions in Gebser v. Lago Vista Independent School District in 1998 and Davis v. Monroe County Board of Education in 1999. These decisions were the first by the court to recognize that sexual harassment can be a form of discrimination prohibited by Title IX. Then, in 2001, OCR published further guidance that, like the 1997 guidance, was based on input from stakeholders. Over the next 10 years, OCR noticed a trend in the nature of the sexual harassment complaints filed with the agency. While many involved allegations of verbal or physical sexual harassment, a growing number involved allegations of sexual violence specifically, which some schools did not investigate as a form of sexual harassment. As a result, OCR issued the 2011 Dear Colleague Letter, extending the standards in the 2001 guidance to specifically address a school's responsibility to respond to sexual violence. The 2011 Dear Colleague Letter was followed by a 2014 Dear Colleague Letter that took the form of a question and answer document, along with a 2015 Dear Colleague Letter clarifying the role of Title IX coordinators. On September 7, 2017, the presidential administration had changed, and the Secretary of Education, Betsy DeVos, gave a major speech at George Mason University where she foreshadowed major changes to OCR's approach to Title IX. A few weeks later, on September 22, 2017, the department withdrew the 2011 and 2014 Dear Colleague letters and issued a new one. The Dear Colleague letter in 2017 noted that the 2001 guidance remained in effect, but set out a different approach to investigations than the one in the 2011 and 2014 Dear Colleagues. In particular, this new approach had an increased emphasis on protections to be provided to respondents during investigations. The Department of Education, under Secretary DeVos, then issued a Notice of Proposed Rulemaking, or NPRM, in November 2018. This was a remarkable shift, as the Department of Education had not issued formal regulations governing Title IX since the 1970s, and any changes made under the regulatory process would presumably have greater legal impact than so-called rule by letter. The department received over 124,000 comments to the NPRM. After more than a year of review at the department and the Office of Management and Budget, the NPRM was issued in final form on May 19, 2020, with an implementation date of August 14, 2020. In the final rules, the department hews to the concepts introduced in the NPRM and adds a number of significant and fairly detailed requirements to the mandated grievance process, while removing other requirements initially proposed in 2018. Some headlines include the requirement for a hearing in college and university complaints, but not in the K-12 setting, detailed notice requirements, detailed letters after findings and appeals, detailed requirements for access to evidence that the institution intends to rely upon and evidence that it does not, and a requirement for live, contemporaneous cross-examination by the advisor of choice of the participating parties. As this almost 25-year history suggests, Title IX cases have become a shorthand for any campus disciplinary process involving sex discrimination, including those arising from sexual harassment and sexual assault. But under the final rule, the institution must narrow both the geographic scope of its authority to act under Title IX and the types of sexual harassment that it must subject to its Title IX investigation and adjudication process. Only incidents falling within the final rule's definition of sexual harassment will be investigated and, if appropriate, brought to a live hearing through the Title IX grievance process. This doesn't mean that the school can't investigate misconduct falling outside the Title IX final rule's scope. If misconduct does not meet the definition and scope of Title IX, the campus can handle the matter through a separate policy in its code of conduct or a parallel sexual misconduct policy. The basic framework for what is sexual harassment covered under Title IX has changed from the 2001 guidance to the 2020 final rules. The 2001 guidance set forth two forms of sexual harassment. The first is quid pro quo sexual harassment, which occurs when a teacher or employee conditions an educational decision or benefit on the student's submission to unwanted sexual contact. The second was that sexual harassment may create a hostile environment. Proving a hostile environment requires a further assessment of whether or not the conduct is sufficiently serious to deny or limit a student's ability to participate in or benefit from the school's program based on sex. However, under the new Title IX rules, the department amends its definition of sexual harassment that is actionable under Title IX. This new definition has three prongs, one prong of which adopts the U.S. Supreme Court's standard in the 1999 Davis case of requiring that harassment be severe, persistent, and objectively offensive behavior. So, under the final rule, sexual harassment covered by Title IX includes conduct on the basis of sex that satisfies one or more of the following. First, an employee conditioning educational benefits on participation in unwelcome sexual conduct, so that would be quid pro quo. Second, unwelcome conduct that a reasonable person would determine is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the educational institution's education program or activity. Or third, sexual assault as defined in the Clery Act, or dating violence, domestic violence, or stalking as defined in VAWA. So when does a school have a duty to act? Well, a school has an obligation to respond to Title IX sexual harassment when it receives actual knowledge of it. As the regulation puts it, a recipient with actual knowledge of sexual harassment in an education program or activity of the recipient against a person in the United States must respond promptly in a manner that is not deliberately indifferent, meaning it is not clearly unreasonable in light of known circumstances. This actual knowledge standard builds on the U.S. Supreme Court's standards in its 1997 Gebser decision and its 1999 Davis decision. The final rule defines actual knowledge as notice of sexual harassment or allegations of sexual harassment to a recipient's Title IX coordinator or any official of the recipient who has the authority to institute corrective measures on behalf of the recipient, or to any employee of an elementary and secondary school. You will note that this standard is a change from the department's long-standing guidance regarding so-called responsible employees. The department no longer applies a constructive knowledge standard based on the subjective belief of a reasonable student. A school's obligation to act depends on notice coming to the Title IX coordinator or an official designated to have the authority to take corrective measures. This narrowing does not mean that a school cannot continue to widely mandate reporting by faculty and staff. The final rule allows schools to maintain the old responsible employee framework if the school believes that is the appropriate policy. Along with changing how institutions receive notice of sexual harassment, the final rules change long-standing guidance about the scope of a school's jurisdiction over Title IX sexual harassment. Again, nothing prevents a school from investigating misconduct falling outside this scope. These regulations simply carve out a jurisdiction where it is defined Title IX investigative and adjudicative processes must apply. So, if the sexual harassment occurs under the following circumstances, the school must apply the Title IX final rules procedures. First, the sexual harassment must have allegedly occurred within the United States. Incidents occurring in study abroad programs would not be covered, but again, a school could cover those through the same or different disciplinary process under their own code. Second, the sexual harassment must have allegedly occurred in the school's program or activities. Generally, the incident must have occurred on campus, although the rules allow for the inclusion of off-campus locations, where the location is part of the school's operations, and the school has substantial control over the location and the respondent. This could, for example, include an officially recognized campus organization housed within a building located off-campus that is owned or controlled by the school. Sexual harassment that occurs online might also fall within the school's Title IX jurisdiction, under the theory that the school's operations may certainly include computer and internet networks, digital platforms, and computer hardware or software owned or operated by or used in the operations of an institution. But the school would need to have substantial control over that forum for its Title IX jurisdiction to be indicated, which may be a complicated task to prove. Before we discuss the grievance process, let's review the requirement that officials not have a conflict of interest or bias. The rule states that officials in the process cannot have a conflict of interest or bias in favor of complainants or respondents generally, or regarding the specific parties in the case. These standards for bias are particular to the new Title IX final rule, but may be useful more generally. The final rule is fairly specific, that an allegation of bias will not stand simply based upon the identity of the official in the process accused of improper bias. The official's gender, current or past work history, and support or opposition to certain causes or issues are not, in and of themselves, indicators of bias, but clear signals of a basis in favor of one party or another would be. For example, The department would likely find a Facebook post from a hearing decision maker that one should, quote, believe all women or all men as evidence of bias. Note that these may still be present as factors in a case-by-case analysis of whether the official is biased specifically or in general. There are a few across-the-board rules that may impact your process, especially if you work at a smaller institution. The Title IX coordinator may also be the investigator, as long as they can do this additional role without conflict of interest or bias. But the coordinator cannot be a decision maker at the hearing or on an appeal. Generally, you will need at least 4 people to do a full process. Title IX coordinator or their designee to coordinate and oversee the process, an investigator, a hearing decision maker, and an appeals officer. The department intends for reports to go directly to the Title IX coordinator and requires schools to widely advertise the coordinator's contact information to achieve this goal. The Title IX coordinator must take specific steps when receiving the report, including offering non-disciplinary supportive measures to the complainant and to the respondent should a formal complaint be filed. Supportive measures must be offered even where the complainant decides not to pursue an investigation. The department does not mandate the measures that must be provided, but suggests a non-exhaustive list that includes counseling, extensions of deadlines or other course-related adjustments, modifications of work or class schedules, campus escort services, restrictions on contact between the parties, i.e. no contact orders, changes in work or housing locations, leaves of absence, and increased security and monitoring of certain areas of the campus. While the final rule surrounding supportive measures is consistent with prior guidance, the rules governing emergency removals are somewhat different. Schools typically have policies allowing them to impose an interim suspension of a student pending the outcome of a disciplinary proceeding based on a risk of harm to the complainant or the campus generally. Now, the department makes clear that interim suspensions are a form of discipline and therefore cannot be issued before the finding of responsibility. Instead, campuses can follow a procedure for making an emergency removal of a student who poses an immediate risk of physical harm to a person. That threat of physical harm has to arise out of the sexual harassment allegations, and the removal decision has to be based on an individualized safety and risk assessment. The removal has to be followed by a, quote, immediate opportunity to challenge the removal that need not be a formal hearing. You can learn more about emergency removals through our companion module on no contact orders, emergency removals, and interim suspensions. The final rules require that schools investigate all formal complaints filed with the Title IX coordinator. A person may file a formal complaint if they are currently participating in or attempting to participate in the education programs or activities of the institution, including as an employee. For complainants who do not meet this criteria, the institution can still investigate using its own code of conduct or other relevant policy. The person who files the complaint will typically be the alleged victim of the sexual harassment, but the Title IX coordinator may also file a formal complaint if the coordinator reasonably believes an investigation is necessary, but the complainant declines to file. The rules, however, prohibit a coordinator from pressuring the complainant to participate in or not participate in the process, which may prove to be a practical hurdle to meeting the standard of evidence if the complainant will not submit to pre-hearing interviews or cross-examination at the live hearing. The Title IX coordinator also has discretion to combine multiple complaints into a single investigation where there is more than one complainant or respondent, or where a cross-complaint has been filed by a respondent against a complainant. Section 106.45(b)(1)(v) requires recipients to set a reasonably prompt time frame for concluding the formal complaint grievance process, and also to set a reasonably prompt time frame for concluding appeals, and, where applicable, informal resolution options. This section does not prescribe a minimum or maximum number of days, but the policy must articulate a number of days. This doesn't have to be 60 days, and it probably shouldn't be given the variety of procedural steps needed before a case is resolved. The Title IX coordinator will send the notice of allegations to the parties as soon as practicable after the filing of the formal complaint, ideally through official campus email. The investigation may not begin until the parties receive the notice of allegations and have sufficient time to review the allegations and understand them so they can respond to questions. This may include sufficient time to find an advisor to help the parties understand the allegations. The notice of allegations must include several pieces of information, including the allegations potentially constituting covered sexual harassment, and sufficient details known at the time the notice is issued, such as the identities of the parties involved in the incident, if any, including the complainant, and the date and location of the alleged incident, if it's known. The respondent also has to be informed they are presumed not responsible until a determination regarding responsibility is made, and that the parties will have the opportunity to inspect and review evidence prior to the hearing, and that the parties have the right to an advisor. That advisor may be an attorney, but it doesn't have to be, and the institution does not need to pay for the costs of an attorney unless that's set forth in the institution's policies. This right to an advisor is similar to that already provided under the Violence Against Women Act amendments to the Clery Act, except that this advisor, or a separate advisor, will conduct cross-examination at the hearing. In other words, there is no potted plant rule allowed under the Title IX final rule, except to the extent that schools can create reasonable policies governing the conduct of advisors in meetings and hearings. These rules could include restrictions on the right to speak on behalf of the advisee, except in the narrow setting of cross-examination. The Title IX coordinator, or designee as consistent with your policy, must dismiss a formal complaint that doesn't meet the statutory criteria for a Title IX complaint. The school may still investigate the misconduct under the Code of Conduct or other relevant policy, so this dismissal is just for the purposes of the Title IX complaint. That official may dismiss a formal complaint brought under the Title IX grievance policy, or any specific allegations raised within that formal complaint at any time during the investigation or hearing as well, if a complainant notifies the Title IX coordinator in writing that they would like to withdraw the formal complaint or any allegations raised within it, the respondent is no longer enrolled or employed by the institution, or if specific circumstances prevent the institution from gathering evidence sufficient to reach a determination regarding the formal complaint or allegations within it. Any party has the right to appeal a dismissal determination using the mandated appeals process. Under the rules, the Title IX coordinator must designate an official to investigate the charges in a prompt manner. Prior to the completion of the investigation, the parties will have an equal opportunity to inspect and review the evidence obtained through the investigation. The purpose of the inspection and review process is to allow each party an equal opportunity to meaningfully respond to the evidence prior to the conclusion of the investigation. Evidence that will be available for inspection and review by the parties will be any evidence that is directly related to the allegations raised in the formal complaint. This will include any evidence that is directly related to the allegations, but that the institution does not intend to rely on in reaching a determination regarding responsibility, and all inculpatory or exculpatory evidence, so evidence that either tends to prove or disprove the allegations, that is directly related to the allegations, whether that evidence is obtained from a party or any other source. That inspection and review process must be for at least 10 days, and then the parties can send a response to the investigator. Schools may set reasonable limits on the review process, such as requiring the parties and their advisors to keep the evidence disclosed confidential. The investigator may then follow up on the responses, including by seeking out further evidence and witnesses. But this duty is not unlimited, and the Department of Education states in the preamble to the final rules that practical limitations, including the school's lack of subpoena power, will shape what amounts to a reasonable investigation under the circumstances. At the end of the investigation, the investigator will draft a report summarizing relevant evidence. That report cannot make a determination regarding responsibility. You can learn more about drafting an investigative report through further SCI resources, including our investigative report template and associated module. Fundamentally, no finding of responsibility can be made under the Title IX final rule without a live hearing. The hearing may be conducted with all parties physically present in the same geographic location, or at an institution's discretion, any or all parties, witnesses, and other participants may appear at the live hearing virtually through video conferencing technology. Any technology may be acceptable as long as it will enable participants simultaneously to see and hear each other and meet security and confidentiality standards. Generally, a hearing will begin with opening statements by the parties, followed by the decision maker asking questions of them and any witnesses. Then, the parties' advisors will have time to cross-examine the parties and witnesses. The final rule prohibits any questioning of parties and witnesses regarding matters that are not relevant. Before any question is asked, the decision maker will have to decide if the question is relevant. In most cases, this decision will be straightforward. Either the question tends to make a fact at issue more or less likely to be true, which will usually be the case, or it has nothing to do with the issue at hand, and is therefore irrelevant. The relevance question is more complicated when the decision maker has to apply the small range of evidentiary exclusions defined in the rule. For one, questions and evidence about the complainant's sexual predisposition or prior sexual behavior are not relevant, unless such questions and evidence about the complainant's prior sexual behavior are offered to prove that someone other than the respondent committed the conduct alleged by the complainant, or if the questions and evidence concern specific incidents of the complainant's prior sexual behavior with respect to the respondent and are offered to prove consent. For another, questions that constitute or seek disclosure of information protected under a legally recognized privilege are irrelevant. Depending on your state, individuals with legal privilege may include medical providers such as doctors, dentists, podiatrists, chiropractors, nurses, psychologists, clergy, rape crisis counselors, and social workers. And questions that call for information about any party's medical, psychological, or similar records are irrelevant unless the party has given voluntary written consent. Finally, a question may be irrelevant if it duplicates another question that has already been asked and answered. The live hearing must include cross-examination. This is a departure even from Sixth Circuit Court of Appeals and California state law precedent, which require public institutions to provide a form of cross-examination in cases resting on credibility. Under the final rules, all cases of sexual harassment at any institution, even where credibility is not necessarily central to the outcome, must include cross-examination. Each party's advisor will conduct live cross-examination of the other party, or parties and witnesses. During this live cross-examination, the advisor will ask all relevant questions and follow-up questions, including those challenging credibility directly, orally, and in real time. If a party or witness does not submit to cross-examination, any statement they made outside the hearing, including statements made in documents such as police reports, SANE examinations, or other documents, cannot be used by the decision maker in making a finding of responsibility. Decisions can be made in the absence of a party or witnesses, but cannot be based on their out-of-hearing statement. The rules also provide a kind of right to remain silent, requiring that a decision maker not draw an inference of responsibility from a party's decision not to testify. Importantly, even if the party or witness is present for cross-examination, if the party or witness refuses to answer a relevant question about a prior statement, then the prior statement can't be used for reaching a determination regarding responsibility. The written determination regarding responsibility will be issued simultaneously to all parties through their institution email account or other reasonable means as necessary. The determination will need to include a lot of detailed information about the history of the case itself and the decision-maker's determination. For example, it must include identification of the allegations potentially constituting covered sexual harassment, a description of the procedural steps taken from the receipt of the formal complaint through the determination, including any notifications to the parties, interviews with parties and witnesses, site visits, methods used to gather other evidence, and hearing held. Findings of fact supporting the determination, conclusions regarding which section of the Code of Conduct, if any, the respondent has or has not violated, and for each allegation, a statement of and rationale for the determination regarding responsibility, a statement of and rationale for any disciplinary sanctions the institution imposes on the respondent, and a statement of and rationale for whether remedies designed to restore or preserve equal access to the recipient's education program or activity will be provided by the recipient to the complainant, and the recipient's appeal procedures. The parties have the right to appeal this dismissal of a formal complaint and the determination regarding responsibility. While the institution can outline its own grounds for appeal, the rules specify that these grounds must include, first, procedural irregularity that affected the outcome of the matter, i.e., a failure to follow your own procedures. Second, that new evidence that was not reasonably available at the time the determination regarding responsibility or dismissal was made, and that could affect the outcome of the matter. Third, that the Title IX coordinator, investigator, or decision-maker had a conflict of interest or bias for or against an individual party, or for or against complainants or respondents in general, that affected the outcome of the matter. Note that all of these appeal grounds have a materiality requirement, so even if a procedural error is identified, the appeal will only be granted if the error affected the outcome. Finally, the final rule, Section 106.71, purports to address Title IX's existing broad prohibition on retaliation. This section prohibits any recipient or other person from intimidating, threatening, coercing, discriminating against any individual for the purpose of interfering with any right or privilege secured by Title IX or this part, or because the individual has made a report or complaint, testified, assisted, or participated, or refused to participate in any manner in any investigation, proceeding, or hearing under this part. The Department states that the retaliation provision in the final rule is purposefully broad in scope. It protects any individual who has made a report or complaint of sex discrimination, including any individual who has made a report or filed a formal complaint of sexual harassment, any complainant, any individual who has been reported to be the perpetrator of sex discrimination, any respondent, any witness, and any other individual who participates or refuses to participate in an investigation, proceeding, or hearing related to the Title IX regulations. Although a wide variety of conduct may constitute retaliation, including acts of intimidation, threats, coercion, and discrimination, Section 106(7)(b)(1) states that the exercise of rights protected under the First Amendment does not constitute retaliation under the final rule. Thanks so much for joining us today to discuss the Title IX Final Rule. We've left on the screen a list of the resources we mentioned today.